Morning.
Good morning.
This is file 22.
See,
192.
Judge, I don't think I can hear you. Let me try something here.
Can you hear me now?
I can hear you.
Yeah, I can hear me too.
I still, oh, you know, it's probably the microphone.
It's Mr. Saloon's problem. Can you hear me now?
Okay, I still can't hear anyone. Judge?
Yes.
I don't think I can hear. Let me try to see if I can. Oh, that might be why.
Can you hear now?
I can.
What have you failed to do?
I'm sorry. Oh, the audio. Yeah, I apologize for that. I thought it was good to go there.
That's why you don't test rocket ships. Let's go to work.
Okay.
This is 22-192-478. Discover Bank versus Tamiko Polk. Date and time for what appears to be our second pretrial. I note for the record that a motion for summary disposition has been filed on behalf of plaintiff. Your respective appearances.
Good morning, Your Honor. For the record, William Saloon, P41487, appearing on behalf of plaintiff, Discover Bank.
And your name, ma'am?
Tamiko Polk.
Okay. We were last together on this file on February the 7th. At that time, the court opened your written discovery. I have a motion for summary disposition that was filed on behalf of the plaintiff. Anybody going to do any written discovery here or not?
From plaintiff's perspective, Your Honor, we don't request any, we don't require it.
Okay.
I don't know about defendant.
What about you, Ms. Polk? Are you going to do any written discovery?
I'm not understanding what written discovery is.
Discovery is your opportunity to learn about the claims and defenses of the other side. It includes such things as written interrogatories, questions to be answered under oath, requests for admissions, and requests for production of documents and things. Those are things that are provided for in the admission courtrooms, and you've elected to represent yourself, as is your right. And then those are the written discovery tools that are available for you. If you're going to use them, let me know. If not, let me know, and I'll just move forward to the motion for summary disposition.
I don't have any written dispositions.
You don't want any doing written discovery? Okay. Then what I'll do is I'll calendar in the motion for summary disposition.
Thank you, Your Honor.
And what exactly does that entail?
Have you received a copy of the motion for summary disposition filed on behalf of the plaintiff?
Yes.
Then I'll set it for hearing. If you wish to file a response, you can file and serve your response, and we'll hear the motion on the next day that I set up for hearing. We'll set it up for hearing April 4, 10 o'clock. Does that work for everybody?
It does, Your Honor.
Okay. Does that work for you, ma'am?
Yes.
Okay. April 4th at 10 o'clock. Written discovery is now closed.
Thank you, Your Honor.
Out to you both today a notice of the hearing on that motion, and thank you both for coming in.
Thank you, Your Honor. Have a good day.
Let's be safe out here.
Thank you.
Thank you.
Thank you. Mr. Smith, good morning.
Good morning, Your Honor.
What file do you have today?
LAFCU v. Crump. Carrie.
Okay. I think we'll be ready to go shortly.
Thank you, sir.
As soon as she connects, we can get started. I got picture, but I don't have audio as of yet. Yeah, here we go. Good morning.
Good morning. I'm doing it for my mom, Jimmy. 1 second. Good morning.
Good morning. We are on the record calling file number 23-140-351, LAFCU versus Carrie Crump. Date and time for what appears to be our first pretrial. Your respective appearances.
For plaintiff LAFCU, Tim Smith, P48259. Good morning, Your Honor.
Good morning. And what is your name, ma'am?
Carrie Elizabeth Crump.
Is it your intention to be your own lawyer here?
I don't have an attorney.
Okay, I'm saying you can hire a lawyer or you can be your own lawyer. You have an absolute constitutional right to represent yourself. What you do not have is to write your own set of rules, civil procedure, your own rules of evidence, your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that are binding on Mr. Smith are binding on you. Do you understand that?
Yes.
Okay. So where are we on this file, people?
Well, Your Honor, there was my client financed the purchase of a Chevy Malibu. There was a default on the contract. Repossession occurred. Suit was filed on what is effectively a repossession deficiency balance owed on the contract. After service, I think the court file reflects an answer filed by the defendant. I believe every box was checked. I disagree with each and every aspect of the complaint. So that's my understanding of where we are, Your Honor.
Okay. And what's your position here, Ms. Crump?
Did you, I don't understand either. Yep, I did. I did say I disagree on.
Okay. All right, then this is what I'm going to do. I'm going to open your written discovery. Discovery, Ms. Crump, is a way by which you can learn about the claims and defenses of the other side. It includes such things as questions to be answered under oath. Those are called interrogatories. Requests for production of documents and things, and requests for admissions. If you elect to participate in written discovery, you must serve whatever you're going to serve on the other side. Anything going forward here, if you elect to represent yourself, anything you file with the other side must be filed with the court. Anything you file with the court must be filed with the other side. You also have the right to hire an attorney, have that attorney file an appearance. The appearance is a document by which the attorney says he or she will represent you. So I'm going to open your written discovery, and I'm going to give you a return date. Your written return date with me will be April 4, 10 o'clock. Does that date and time work for everybody?
Your Honor, it works for me. You bet.
That work for you, Ms. Crump?
Yes.
Okay, so here's what I'm going to do. I'm going to send out an order today for April 4th. April 4th at 10 o'clock. We'll be on Zoom like today. I'm going to open your written discovery. Now, what I'm going to do now is I'm going to put you two into a chat room so you can talk about your case outside of my hearing. If you settle the case, come back to me. If not, I'll see you April 4th at 10 a.m. Thank you both for coming in.
Thank you, Your Honor.
Can I ask you a question?
Ma'am?
Okay, well, I mean, can I get me appointed attorney?
Ma'am, we only appoint attorneys in criminal cases.
Oh,
This is a civil
okay.
case. Yes, ma'am.
All right.
You might want to try, let's see, Lakeshore Legal Aid does civil defense for free. Both of the law schools, Wayne State and U of D Mercy, have clinics where they provide little litigation. State Bar of Michigan, you can go on the website. They have people who provide free representation, and you might find some more information on the Supreme. That's what do we got? Carter. Let's see, I got Ruser. So this is who I guess I need to find. Hello?
Yes.
What is your name?
Tammy Walton.
All right, hold on for just a second. We are on the record calling file number 23-140007, Credit Corporation Solution versus Tammy Walton. Date and time for what appears to be our first pretrial, your respective appearances.
Judge, may it please the court, my name is Attorney Richard Roos, and I'm the attorney of record for the plaintiff. My bar number is 35222, and I'm also the attorney of record for the plaintiff in pretrial today.
And what is your name, ma'am?
Tammy Walton.
Ms. Walton, is it your intention to represent yourself in this matter?
Obviously, I guess so, sir, because I've been trying to seek legal counsel through the court, but they told me that with this matter, I wouldn't get a counselor.
Well, you don't get an appointed lawyer, but you can hire a lawyer for yourself, or you can check
Yeah.
in one of the places that might provide legal aid, say Lakeshore Legal Aid, both the law schools in town, Wayne State, as well as the UD Mercy, have clinics that provide free legal services as well. The Detroit Bar Association has lawyers who provide free legal services, and the State Bar of Michigan. You can check those websites as well. Okay, so
Yes, yes, sir. I definitely will, but because I've never been to court for being sued or any other matter, I didn't have knowledge of those places. Plus, the hours that I work at my job didn't permit me to be on the phone all day. But I'm here. I can definitely explain my situation, why I came to be to this point, but I don't have legal counsel at this moment.
all right, we will proceed then in the absence of counsel. If you get a lawyer, have the lawyer file the appearance. The appearance is a document by which the lawyer says he or she will represent you. So what I'm going to ask you, Mr. Rusin, what's your case about here?
Judge, I have a case that's on your docket as an assigned debt. It's a first-time assignment. I was looking at the 60 credit card statements. It was a credit card under the brand name of Surge. They all went to Miss Walton at her McKay Street address. The amount of the suit is $1,131.86, which was the date of the last, the amount of the last statement prior to charge off, and then placed in litigation with your court. So I would ask for discovery so I can send these statements to defendant. She can review them, review the veracity of them. If she wants to contact my office to talk about settlement, or she's invited to do so anytime between Monday and Friday, 8:30 a.m. to 7 p.m. On that, I rest.
So what I'm going to do is I'm going to open your written discovery. I'm going to give you both a return date. It'll be on Zoom again like today. That return date will be April 4, 10 o'clock. Does that work for everybody?
Yes, Judge.
Does that work for you, ma'am?
Well, I will have to see if I can get off work because I work at the city county building. And I'm not always able to, depending on if I have any vacation days. But, I'll just tell them it's court, but I just don't know exactly yet till at least ask my superiors if I'm good to have that day off.
You don't need the day off. You don't have to come in person. We're doing this on Zoom, so you don't have to take a day off from work.
Okay.
Calling in on your cell phone. You can do that. Okay, April 4th, 10 o'clock. We'll send you out an order. Anything else we can do today?
At this time, play press, Judge.
Anything for you, ma'am?
So this is what I wanted to know. So today, what was the purpose of today? Just setting a day. So when I come back to court, what will happen? I mean, we have another Zoom meeting. What will happen on that day to get resolved with this matter? Because I had 2 credit cards through them. I'm going to have to go to court April 18th for that. So I thought today this matter was going to get handled. So I'm just trying to see when I will be able to get this matter resolved.
Well, ma'am, I can give you and Mr. Rusin a chance to talk about. I'll put you in the chat room and you can talk about resolving your case.
Okay.
All right, I'll do that after I let you go. So April 4th at 10 o'clock, your written discovery is now open. Now let me get you into a chat room so you can talk about resolving your case. Mr. Corpus,
Good morning, Your Honor.
what brings you here today?
It's a pretrial, Woodbridge Estates versus Janai Lindsay.
Okay. I have one person who I don't know who they are. So let's see if this is she. All right, put you back in the waiting room and I'll figure out who she is.
Okay, thank you, Judge.
Samsung here. Hello,
Hello,
what is your name?
my name is Janae Lindsay.
Okay, let's get Mr. Corpus in here. Let's get started. She was here a moment ago. Don't go away.
I'm not going anywhere.
All right, we're back on the record, calling 22-198-388. Woodbridge Estates versus Janae Lindsay. Date and time for pretrial. Your appearances.
Good morning, Your Honor. Matthew Kuiper is on behalf of the plaintiff.
Bar number.
E71348.
And what is your name, ma'am?
My name is Janae Lindsay.
Ms. Lindsay, is it your intention to represent yourself in this matter?
Yes, I am.
You have an absolute constitutional right to do that. What you do not have is the right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind Mr. Kuiper are binding on you. Do you understand that?
When you say I can't use my own evidence, I'm just confused why I'm being
I didn't say
sued.
that, ma'am. I said you can't, don't get your own set of rules.
Okay, yes, I understand.
Listen to what I say. Don't put words in my mouth.
Okay.
Mr. Kuiper, what is your claim about?
Your Honor, this is a claim for post-tenancy damages, mainly past due rent from, it looks like July to November 2021 in the amount of $7,104.95 plus cost.
Okay, this is what I'm going to do. I'm going to open your written discovery and I'm going to give you guys a return date. Your return date with me, it'll be Zoom like today, April 4th at 10 o'clock. Does that date and time work for everybody?
Yes.
Yes, Your Honor.
Okay. Anything else we can do today?
Yes, I have a question, Your Honor.
Yes, ma'am.
This was dismissed. That's why I'm trying to figure out why I'm being sued.
What do you mean this was dismissed?
This was dismissed. I can to show you from Judge Coleman. It was dismissed. It said the court further orders Janae Lindsay is dismissed. This was dismissed 10/21/2021.
What's the case number in the upper right-hand corner?
The case number is 213-50846. This is somebody else suing me. I was originally sued by.
What are the last two digits? That should be two letters after that. After the numbers, there should be two letters.
Are you talking about the bar number?
No, I'm talking about the case number that you just gave me. To the right of that should be two letters.
It just say 213-50846 Jones Coleman.
Okay, that's a landlord-tenant case.
This is the same.
Well, look.
I'm not making my own rules. I'm listening. I'm not cutting you off.
The landlord-tenant case was about possession of the property. Who has the right to possession of the property? This is a claim that money is due as a result of your tenancy in that property. They're two separate claims. You understand?
I do understand, but the judge told me I can stay there, that I didn't have a move. It was the middle of COVID. Nobody was renting.
That's not what this claim is about, ma'am.
Okay.
Again, like I told you, that was a claim for possession of the property. And the judge said you could stay there. The judge did not say you could stay there rent-free.
The judge
this is a claim that rent and damages to the property were made, and that's what this is for. Two separate cases.
So can I ask you, when I went to court the first time, they didn't enter a judgment. They wasn't asking for rent. Because
I understand that. And again, in the landlord-tenant division, people as landlords can ask for two things. They can ask for possession only, or they can ask for possession and money.
They was only asking for possession.
That's the point I'm making.
Okay.
Since that was the only thing that was before the court, the question of whether you do or don't owe money as a result of tenancy has not been adjudicated. That's what's for me.
Okay.
April 4th at 10 o'clock. The written discovery is now open. Thank you both for coming in. Yes, ma'am. We're off the record.
Thank you, Judge.
Have a great day and let's be safe. Mr. Carter, good morning.
Your Honor, how are you?
Great. What brings you here?
I have,
XLNC?
no, sir. I have credit acceptance versus Natasha Hicks.
Credit acceptance versus Natasha Hicks?
Correct.
I have that on my list today. What is your case number?
22-200-457 GC.
22-200-457.
Correct.
Okay, you're not on my list. My clerk is looking it up right now, and she should be calling me shortly.
Sounds great. I think it was a control date. I think we put the settlement terms on the record and we were gonna send in settlement documents, but the defendant never sent them back to us, so.
Here's my my court clerk. Can you hang on?
Yes.
Mr. Barter?
Yes, sir.
Case was dismissed without prejudice, noting a conditional dismissal to follow. And the conditional dismissal apparently has not followed.
Correct, because a conditional dismissal has to be signed by a defendant. So if a defendant never signs it, never sends it back to plaintiff, then plaintiff, so the case just, so we'd have to file a motion to reopen the case because the defendant didn't send it back to us?
Yes. Did she get it? Because you typically offer terms better than your complaint. Why would she not sign it? She agreed to the terms on the record.
She said that she didn't receive it.
Okay.
So, in a voicemail, and we've been trying to call her back to get an email to send it to her.
Send a snail mail again. That's all you can do.
All right, perfect. And then if she's never to sign it or never contact.
Counsel?
Good morning, Your Honor.
This is 22-197-787. XLNC Investments LLC versus Ebony Fareed. The date and time for pretrial. Can I have your appearance?
Good morning, Your Honor. Randy Levasseur, P41712, appearing on behalf of the plaintiff.
Mr. Levasseur, this is our first pretrial. By a notice dated February 7, 2023, this matter set for pretrial today, March 7th at 10 o'clock. It's now after 10:30. Defendant has failed to appear. No good call that failure having been shown. The defaulted defendant is hereby entered. We'll send that out to you today, sir.
Thank you, Your Honor. I believe the defendant has already been defaulted.
No, she filed an answer.
Prior to that, we filed a default with the court for failure to answer. I believe the court entered that, and then she filed an answer subsequent to that without having set that default aside.
Well, in any event, we'll default it again.
Thank you, Your Honor. We will file the appropriate motion for entry of judgment.
Thank you. Have a
Thank
great
you.
morning.
Good morning, Your Honor. For some reason, my name is all messed up. I'll have to change that real quick.
This is Consumer Portfolio Services versus Tiffany Sewell. Case number 22-194-604. Your appearances.
Franco Barilli, attorney for the plaintiff, Consumer Portfolio Services.
Bar number.
P69468.
And what is your name, ma'am?
Tiffany Sewell.
Okay, this is our third pretrial on this file. Your written discovery has been open since January 10th. How are we doing on that?
Well, I was waiting on a response from Miss Alyssa. She said she was working to get me a response, and I was telling her, hey, I was trying to solve this before we went back to court. She said she still hadn't heard anything back. So she was like, I'm gonna try to get you a response before 11, but I just checked my email again, and I haven't got anything back.
Counsel?
Yeah, Your Honor, those are settlement discussions. As far as
Okay.
discovery is, in my mind, it's closed. I've submitted all documentation to Ms. Sewell. I do not have any no requests that need to go out, and I have not received any discovery requests from Ms. Sewell.
Ma'am, are you going to do any written discovery?
I'm not sure exactly what that is. I thought I was supposed to be going back and forth with her to find an agreement.
Written discovery is your opportunity to learn about the claim.
You're muted. I can't hear you.
I'm not muted.
Hello?
Can you hear me, counsel?
I can hear you, Your Honor.
I can't hear anything you're saying.
Well, ma'am, I don't know what to tell you. Counsel can hear me now. My microphone is not muted. That's on your end.
Can you hear me?
Yes, I can hear you.
Okay, now I can hear you. Can you repeat that? I'm sorry.
I'm asking of you, do you intend to do any written discovery? Written discovery is your opportunity to learn about the claims and defenses of the other side. It includes such things as written questions to be answered under oath. They're called interrogatories, requests for admissions of facts, and demand for production of documents. Are you going to do any of that? Or are you prepared to go forward? I mean, you've had discovery open now for 2 months.
Yes, but I'm sorry. I thought that we were at a different point.
Okay, well, this is what I'm going to do. I'm going to give you guys a return date of April 4th at 11 o'clock. Your discovery will close April 1st. We'll be on Zoom like today, April 4th. Counsel, good morning.
Hi, Judge. How are you?
Good. How about yourself?
Not too bad.
What file do you have?
The last three are 695. It's credit acceptance and Bryson.
Okay. I don't seem to see that name. So back to the waiting room you go.
Sounds good.
All right. Let's see. Let's try this iPhone. Morning. Hello? No audio. Hello?
Good morning, Your Honor.
What is your name?
My name is Joelle Wright Terry on behalf of Memorials by Marshall Sassy, INC.
Okay. You are a small claim appeal. Small claims appeals are done de novo, but they're done off the record. So you will be at the end of the call because I have to do all the other cases that I have to do on the record. Then I have to go shut off the record and come back and do you. Okay?
Yes, sir.
Just to let you know, you are iPhone. Hello? Hello?
Hello,
What is your name?
my name is John Kane.
Okay, so you're Motorola.